Good morning. Can you all hear me? What do I do? It is muted. Hold on for a second. We got a little technical issue.
There.
Okay. Let's try that one. Can y'all hear me?
I can now.
All right, perfect. Sorry, we had a little technical difficulty. We're going to cause number 9354 in the estate of Betty. And I'm sorry, I've got people helping me with this because my technology is not that great. So thank you. Could I have the parties please announce?
Yes, Your Honor, my name is Lennon Wright. I represent Curtis Cogburn, the executor of the estate.
Okay. And ma'am, could I have you announce? I can't hear you if you're talking. I can't hear you.
Your Honor, can you hear me?
Hear you now. Yes.
Good morning. Good morning, Judge. Jasmine Sharma here on behalf of defendants Waddell and Reed and Linda Howard.
Okay. Are both parties ready to proceed?
Yes, Your Honor.
Okay. The first item I've got here is an order granting an unopposed motion for admission pro hoc vice for Ms. Sharma. There's no objection to that, Mr. Wright?
I have no objection, Your Honor.
Okay, then I'm going to go ahead and sign that order to allow Ms. Sharma to come in pro hoc vice. Second, then we have I'm going to go ahead and let the defendants start on their motion to compel. And let me make sure that I haven't missed anything. Are those the two matters that are before me right now? The motion to compel arbitration and the order to admit Ms. Sharma. Am I missing anything else?
No, Your Honor.
No, Your Honor. I believe we are waiting for an Eric Charton. He's co-counsel for defendants.
All right, let me just see if he's, I do not see him at this moment.
Mm-hmm.
Do you want to see if you can reach out to him or have somebody from your office reach out, Ms. Sharma?
Do you mind, Judge, if just a minute? Let me just.
I do not mind at all. I did notice Mr. Charton is on most of these pleadings.
Yes,
so
Your Honor.
I would suggest he might want to be here.
Yes, Your Honor. I just messaged him, Judge. Hopefully he should be here shortly. If not, I'm happy to proceed.
Okay. We'll give him a few minutes if that's okay with you, Mr. Wright.
It is.
All right, thank you.
Thank you, Judge. Thank you, Mr. Wright.
So are you guys, while we're waiting, are y'all having live hearings in Houston, Mr. Wright?
Not yet, Your Honor, but they're talking about doing that in the fairly near future. I think like August or September.
I got you. Ms. Sharma?
Your Honor, I'm in St. Louis right now. I do a sort of a whole host around Missouri. We've been doing a lot of Zoom, WebEx, and quite a few live and in person.
Good. We started live hearings April 1st here. So we're kind of moving forward with trying to get back to what would become considered normal in our world, but I'm not certain that we'll ever get back to full normal. It is.
Yeah, Judge, I don't know what normal means anymore.
Well, I guess as long as we have to rely on technology, then I'm at a disadvantage because I'm not a technology person. So I do like in-person things a lot better. Which, by the way, we are recording this in case y'all are wondering.
Is that routine, Judge?
You know, it's generally up to y'all, but since this is a hearing that I may want to go back and listen to, I went ahead and put it on the recording so I can make sure if I miss any notes, I can go back.
That makes sense.
It's typically up to y'all as to whether or not we want to record it. We actually are a court of record, and we do not have court reporters. We have court recorders in this court, which is I don't know how y'all do it in St. Louis, but in Texas, most courts do use reporters, but this particular county court of law has a recorder. And we have official court recorders, so we record everything anyway. How about in Houston? Do they do that, Mr. Wright?
Scott Brister was the only judge in Houston who did it as a trial judge, and that was 20 some odd years ago. And it made for a complete zoo in the event there was an appeal because the record was unintelligible.
Yeah, they've come up with a whole lot better technology right now because the record is as clear as what the court reporter records when they're recording.
20 years was a long time ago.
Yeah.
For audio technology and video technology for sure.
In Missouri, do they do it, Ms. Sharma?
It really depends on each judge. I know county circuit does the they type everything out. But if we're in the city, they have a recorder. So I guess it really just depends.
Depends on the court.
Yes.
Gotcha. Have we heard from Mr. Shorten?
I have not, Judge. I'm happy to continue.
Okay, then if it's good with you, maybe he'll join us eventually or not. So we're going to go ahead and proceed. And I believe, Ms. Sharma, it's your motion.
Mm-hmm. Yes,
so I'll go ahead and let you start.
Well, again, good morning, everyone. I appreciate everyone appearing today. This is on defendants, or my name is Jasmine, as you all know. I represent defendants Waddell and Reed and Linda Howard on a defendant's motion to compel arbitration in state proceedings. Throughout the presentation of my motion today, any mention of defendants will only refer to our clients, Waddell and Reed and Linda Howard. So before getting into the substantive legal argument today, just a little bit of background on these facts. Betty Cogburn made her daughter, Courtney Davis, her power of attorney in May of 2017. This power of attorney is Exhibit B of defendant's motion to compel arbitration in state proceedings. In January of 2018, Courtney Davis, acting as the power of attorney for her mother, Betty Cogburn, opened a transfer on death or TOD investment account held through WRI with the assistance of Ms. Howard, who's the financial advisor at WRI. Ms. Davis signed an account agreement when the investment account was established. The account agreement is Exhibit A to defendant's motion, and it forms a contractual relationship between WRI and the financial advisor, Howard, on one hand, and the power of attorney and the account holder, the power on the other hand, the account holder being Betty Cogburn. On page 3, section 5 of the account agreement, there's an arbitration provision which expressly states any controversy or dispute arising from defendant's involvement must be arbitrated. Chase and Courtney Davis were the named beneficiaries on the TOD investment account. Unfortunately, in November of 2019, Betty Cogburn passed away. As per the beneficiary designations on file with WRI, $70,000 was distributed equally amongst the named beneficiaries, Courtney and Chase Davis. Mr. Cogburn, as his mother's executor, filed suit on December 15th.
Can I ask a question? Was
Yes, Your Honor.
was that money transferred pursuant to the pay on death provision?
Correct, Your Honor.
Okay. I didn't see that in these documents, but I heard you say, so there was a pay on death in the Waddell Reed documents, paid on death equally to Chase and Courtney?
Correct. 70,000 distributed equally.
All right, thank you. Keep going.
Thank you, Judge. And we believe the legal argumentation here is fairly straightforward because all of the claims at issue are within the scope of the arbitration agreement, and all of the parties in this matter seek benefits from the services provided by defendants and are seeking money that was invested in and eventually left the account. Defendants moved to compel arbitration in this matter to FINRA, which is the Financial Industry Regulatory Agency. And FINRA is a regulatory agency that regulates brokerage firms and essentially deals with the type of matters that we're discussing today. When deciding to compel arbitration, a court should consider two different things. One, whether there is a valid agreement to arbitrate a dispute, and two, whether the claims at issue are within the scope of the arbitration agreement. Here, we have both. There is a valid agreement to arbitrate a dispute, and the claims at issue are squarely within the scope of the arbitration agreement. Here, all of the terms and provisions in the account agreement govern the relationship between WRI and financial advisor Howard on one hand, and the power of attorney and the account holder, Betty Cogburn, on the other hand. Here, Mr. Cogburn is stepping into the shoes of his mother, Betty, as his executor to recover damages that she is allegedly entitled to based on the services provided through the account agreement and distributions from the account. Here, based on plaintiff's response, plaintiff will likely argue that because Mr. Cogburn did not sign the agreement, he shouldn't be subject to it. Judge, taken to its logical conclusion, an executor's job is rendered essentially meaningless if the executor would have to sign each and every contract or agreement that the decedent also signed in order to sue on behalf of that decedent. We believe that that essentially makes every executor's job impossible and meaningless and, frankly, contrary to law. Here, despite having a valid agreement to arbitrate plaintiff's claims, which fit squarely within the scope of the arbitration agreement, plaintiff curiously today, Judge, wants to cherry pick which provisions of the agreement should apply and which should not. Specifically, plaintiff doesn't want to be bound by the arbitration agreement on page 3, yet wants to rely on the existence of the account agreement and is trying to seek damages from the relationship that is created by the account agreement. I submit to you, Judge, that plaintiff cannot have it both ways. Either the plaintiff gets to seek benefits from the account agreement and is bound to the entirety of the account agreement and provisions, including the arbitration provision, or he cannot seek any damages related to the account agreement, and the court should dismiss this case. As I stated before, the parties have agreed to arbitrate and there is a valid agreement. Mr. Cogburn is a party to this agreement and should be compelled to arbitrate. Texas Supreme Court has held a non-signatory should be compelled to arbitrate if the claim seeks to derive a benefit from the contract containing the arbitration provision. Here, on page 4 of the petition, plaintiff states that plaintiff will show defendants showed fraudulent transactions with regards to the managed account. Related to claims of the Texas Deceptive Trade Practices Act, Mr. Cogburn states defendants are liable for representing that the account had benefits that it turned out not to have. On page 5 of the petition, Mr. Cogburn is suing based on the account agreement itself. He states that defendants are representing that the brokerage agreement conferred or involved rights that it turned out not to have. In addition, Judge, as I stated, Mr. Cogburn, as Betty Cogburn's executor, steps into the shoes. That's Texas Estates Code 351054. Again, a requirement that the executor would have to be a signatory and sign each and every agreement the decedent also signed renders their job essentially meaningless and impractical. And Ms. Davis and Chase Davis are also a party to this agreement and should be compelled to arbitrate. Based on the intertwined claims doctrine in Texas, a non-signatory defendant has a close, when a non-signatory defendant has a close relationship with a signatory that contains an arbitration agreement, a court can compel that defendant into arbitration. And here, Ms. Davis and Chase Davis have a relationship with the signatory, Betty Cogburn. And here, on plaintiff's response, page 3, they don't dispute this. They do state that the true signatory on this contract is Courtney Davis, suspiciously. Again, also plaintiff confuses our argument. They state that Ms. Davis doesn't have a close relationship with her brother and thus should not be compelled to arbitrate this dispute. Again, Judge, our position is that Courtney Davis and Chase Davis should be compelled because they are non-signatory defendants and have a close relationship with Betty Cogburn, the signatory. Here, they do have a close relationship. Courtney Davis is the attorney in fact and is also the daughter. Chase Davis is also the grandson of Betty Cogburn. Additionally, an additional reason why Chase and Courtney Davis should be compelled to arbitrate is if the agreement itself, per Texas law, names a non-signatory as a recipient of benefits under the contract, a third-party beneficiary theory will bind the signatory. Here, Ms. Davis and Chase Davis are named beneficiaries of the account, and thus both her and Chase received portions of the funds and binding Ms. Davis to the agreement's arbitration clause. In addition, Judge, the issues fall squarely within the scope of the arbitration agreement. The Federal Arbitration Act, Section 2, requires the enforcement of contracts providing for arbitration, where all contracts related involve commerce. That's 9 U.S.C. 2. Here, the agreement relates to transactions between Mrs. Cogburn and WRI and the national securities market, thereby invoking and involving commerce, thereby invoking the Federal Arbitration Act. Here, plaintiff states and haphazardly ignores the Federal Arbitration Act and instead says the FAA only applies to signatory agreements. Judge, that's false. The FFA is applicable here because it involves a contract involving commerce. In addition, in Texas, when there is a reasonable relationship between the subject matter of the dispute and the underlying agreement, the dispute is within the arbitration provision. Here, not only is there a reasonable relationship, there is a clear and causal relationship between the parties or plaintiff's claims and the underlying agreement. Again, page 4 of plaintiff's petition, they state that plaintiff alleged that defendants conspired to deprive the other heirs instead of a managed account. Page 4, plaintiff states that there is a breach of fiduciary duty and defendants will show fraudulent transactions. Judge, the account agreement creates a fiduciary relationship, and now plaintiff is claiming there is a breach of fiduciary duty. That is a causal, very clear connection here. If not for the account agreement, plaintiff would not be bringing his claims here today. In addition, the Federal Arbitration Act and the Texas law strongly favor arbitration. The Supreme Court of the United States and Southland Corps direct courts to favor or direct that courts should favor arbitration and resolve disputes concerning the coverage of the arbitration agreement and read provisions broadly and with preference for arbitration. In addition, Texas law strongly favors and public policy strongly favors arbitration here. In addition, the Federal Arbitration Act, the Texas Arbitration Act, and Texas Civil Practices and Revenues Code require a court to stay a proceeding involving an issue subject to arbitration. In addition, Judge, in order to override the clear law and facts that we have today, the plaintiff must present, and I quote, forceful evidence of a purpose to exclude the claim. Here, plaintiff has not done so. They have stated no public policy reasons that should override the clear public policy in favor of arbitration. And very clearly, plaintiff has put itself in a double bind. Plaintiff wants to seek benefits from the account agreement and seek benefits from the account agreement that creates the relationship we're here today, and wants to cherry pick which provisions and which parts of the agreement that they should benefit from, but then they say they should not be subject to the arbitration agreement. I submit to you, Judge, that they should be held by the entirety of the account agreement and also the arbitration provision on page 3. And with those arguments, Judge, I respectfully request that this court stay this action and compel arbitration as required by the agreement, the Federal Arbitration Act, and Texas law. Thank you.
Quick questions, Mr. Wright, before you proceed. Like I said, I did not see the actual, I guess I don't have the full agreement. Who are the beneficiaries of the agreement? The named beneficiaries.
Courtney Davis and Chase Davis.
Okay, and then on page 3 of the arbitration agreement, where it says paragraph 5, how do you interpret B, where it says arbitration awards are generally final and binding?
What do you mean, Judge?
I guess my question is it a, I understand the paragraph starts with binding arbitration, but then it also suggests it's generally final and binding, but doesn't say it shall be. So I'm asking you, are you asking for binding arbitration, or are you asking for just arbitration? I didn't see binding anywhere in your arguments, and that's why I'm asking. And I see Mr. Chartrain's on, but you're muted if you want to speak, Mr. Chartrain, but anyway.
Thank you, sir. And I apologize for joining late. My wife had emergency surgery that bled into this morning, and I just got back to my house about an hour and a half ago. So
Hope she's okay.
Yeah, forgive me for being late, and apologies to counsel as well. Your Honor, the only reason why the word binding would not be there is because there are narrow circumstances where an arbitration award can be overturned. The standards are pretty high, and I'd say 99.9% of arbitration awards, especially out of FINRA, are not overturned. But the law does allow for certain arbitration awards to be overturned in very limited circumstances. And so binding is, as a heading, is meant to, inform the customer that these are full and final awards. But as Your Honor probably will, is aware, that there are certain circumstances, limited ones, where an arbitration award can be overturned, such as arbitrator bias and other circumstances that come to light after the fact.
Okay. Thank you. Mr. Wright?
Yes, Your Honor. Let me back up, and I'd like to give the court some more background as to what happened here. Linda Howard and Courtney Davis have been friends for more than 20 years, maybe more than 30 years. And in any event, Courtney Davis informed Linda that she had been given power of attorney by her mother. And then the two of them obviously had some conversation about getting together, because Linda Howard met Courtney Davis at the Hondo National Bank, where Betty Cogburn had 2 CDs payable upon death, $40,000 to Courtney Davis and $30,000 to Chase Davis. And then the two of them, Linda Howard and Courtney Davis, opened up an account at Waddell and Reed. Now, when they cashed in the CDs, I assume at the bank, and then took the $70,000 in cash and used those funds to open up the account at Waddell and Reed. Now, at the same meeting, Linda Howard was shown the will that Betty Cogburn had made, And in her will, Betty Cogburn left her estate in 3 equal portions to her 3 children, Courtney Davis, Curtis Cogburn, and Susan Wright. At the time that the Courtney Davis entered into the account with Waddell and Reed, it's very important to note that she never signed the agreement in her individual capacity. She only signed the account as Betty Cogburn and noted that she signed it on the basis of her power of attorney. Critically, in the agreement with Waddell and Reed, the language that is not there is significant. The court has seen many agreements where the person entering into the contract says, and this agreement is binding upon my heirs, my estate, my executor, and my assigns. That language is nowhere present in the Waddell and Reed agreement. Rather, the only people that are bound by that agreement are, in this case, Waddell and Reed and Betty Cogburn. Betty Cogburn is no longer with us. So the next thing I want to go to is that Linda Howard and Courtney Davis then made the account payable upon death instead of the estate, which they should have done, but payable on death in the amount of $40,000 to Courtney Davis and $30,000 to Chase Davis. Then what happened is that this was a quote managed account, and it looks like at some point in time options were purchased. Courtney Davis wouldn't know an option if it bid her. And in any event, time goes by, and Courtney Davis uses a lot of the funds on her own personal expenses, her mortgage, her car payments, and what have you. And then at some point in time, Courtney Davis informed her siblings, Curtis Cogburn and Susan Wright, that her mother's house would have to be sold because the funds were running low and they needed more funds so that the nursing home could be paid. So the house was sold. Approximately $135,000 went into the account, and it was only a few months after that that Betty Cogburn died. Now, as we pointed out, Curtis Cogburn never entered into this arbitration agreement. Susan Wright never entered into this arbitration agreement or the account agreement with Waddell and Reed. But significantly, Your Honor, Courtney Davis never even entered into this agreement with Waddell and Reed. Like I've said, the only person that entered into this agreement was Betty Cogburn with Waddell and Reed. Now, they want to hold Curtis Cogburn to this arbitration agreement, even though he never signed it. And I'd like to cite the court again to the Supreme Court case that we cited in our response that says that arbitration is a matter of contract and nobody can be forced to submit to arbitration unless they've agreed to do so. And in this case, we also pointed out in our response, Your Honor, the Texas Supreme Court decision in the Judy James Farms versus the Altman Group, Inc. And this is a significant holding by our Supreme Court about when a non-signatory can be forced to go to arbitration. And in its opinion, the court sets out several areas, and I think it's a total of 6. And they are, number 1, an incorporation by reference. Number 2, assumption. Number 3, agency. Number 4, alter ego. Number 5, equitable estoppel. And 6, third-party beneficiary. And in this case, there's no incorporation by reference, and there's no assumption. There's no agency. Curtis Cogburn was never an agent for his mother, and alter ego is not applicable here either. The third-party beneficiary agreement is clearly not an issue here, and Waddell and Reed never entered into the management agreement with the intent to bind Curtis Cogburn to the arbitration clause. Then the next thing that they argued, they said, well, the plaintiffs are cherry picking the agreement. Your Honor, we're not cherry picking the agreement at all. We are alleging common law claims and deceptive trade practice claims against Kim Howard, Waddell and Reed, and Courtney Davis. Our claims have nothing to do with the agreement that Courtney Davis signed on behalf of her mother with Waddell and Reed. The last issue that they have raised is that the intertwined claims argument. Now, the Supreme Court in the Jody James Farms case also talked about that theory, which has been advanced by one of the Texas Court of Appeals. And the Texas court specifically noted that it had not yet made a decision as to whether or not to accept that theory. But in order for that theory to apply, number one, the parties have to have a close relationship. Courtney Davis, Curtis Cogburn, and Susan Wright don't have close relationships as contemplated by the Second Court of Appeals opinion. And the next thing is that the claims that are being asserted don't have anything whatsoever to do with the items that are enumerated in the agreement that Courtney Davis signed with Waddell and Reed on behalf of her mother. So in this case, Your Honor, we believe it would be unconscionable to hold Curtis Cogburn or force Curtis Cogburn to go into arbitration instead of letting him litigate his common law claims and his deceptive trade practice claims when he was never a signatory to the agreement. The citations by the defendant and the arguments by the defendant about the federal arbitration agreement, the Texas arbitration laws, that verbiage applies when somebody has signed the arbitration agreement. Curtis Cogburn never signed the agreement, never entered into any sort of the agreement, and the 6 exceptions noticed by the Supreme Court in the Jody James Farms case don't apply. So therefore, Your Honor, we think it would be inappropriate for Curtis Cogburn to be forced to arbitration.
Before I let you respond, wanted you to just the inventory that was filed last year shows roughly $100,000 cash on hand, of which there's about 92 in Waddell and Reed. Is that 92,000? That does not include the 70 that was distributed. Is that correct? Or
no, it does.
It does include the 70 that was distributed.
Yes.
So that 70, if I understand right, was distributed on a POD, right?
Correct.
Yes.
And then I think I heard you, Mr. Wright or Ms. Sharma, say that 70,000 came to Waddell Reed from Hondo National Bank, where it was in accounts that were also POD to Courtney and Chase. Is that correct?
That's correct too. Okay. But the 70,000 that was distributed after Betty Cogburn's death came because of the way the account was structured, so that the remaining funds in the account were distributed $40,000 to Courtney and $30,000 to Chase.
So what you're telling me is the 72,000 in the Waddell and Reed on the inventory, that 70 is in that number.
I think it was 92,000 that was in the Waddell and Reed, and that's at the time of death. So between the time of death and the money that got distributed,
okay.
So that would be an extra 22,000, I assume.
Okay, and what happened to the 135,000 from the sale of the house?
It went into the Waddell and Reed account.
Okay. Okay. Response from one of you, if y'all would like.
Yes, Judge. Responding to a few points that plaintiff's counsel raised, they state that this Texas Supreme Court case none of those specific 6 conditions apply. Judge, we disagree completely. We specifically argue, based on the third party theory, binds both Courtney Davis and Chase Davis to arbitration. For one, that's the Ace M case that we cited. The agreement here can name a non-signatory as a recipient of, if the agreement names the recipient of benefits under the contract, third-party beneficiary theory will apply and bind those parties. Secondly, they state that the language itself of the agreement doesn't contain the typical sort of language we see will bind the heirs, et cetera. There's no case law. There's nothing that exists that says if you don't have that language in the contract that says that this contract will bind the rest of your heirs, et cetera, that state that anyone who doesn't sign that agreement will not be subject to that agreement. And Judge, I will submit to you that here, Mr. Cogburn is again cherry picking. He is saying he is trying to benefit, and I use the example for the breach of fiduciary duty here. There would be no fiduciary relationship if not for the account agreement. So without this account agreement, plaintiff would not be able to sue based on breach of fiduciary duty. And thus, I'm not quite sure why plaintiff is saying that these claims have nothing to do with the account agreement when the account agreement itself governs the relationship between the parties. Yet plaintiff counsel is saying that these claims have nothing to do with that account agreement. Yet he's trying to base off many of their claims and damages and distributions based off the relationship that's created by the account agreement. And that's why we're saying he's cherry picking, because he's trying to benefit from the relationship that's created by the account agreement, but then saying, oh, but we don't want to be subject to the arbitration provision. And again, just to state, he's saying that because Mr. Cogburn didn't sign the signatory agreement, or didn't sign the agreement, he shouldn't be subject to it. Judge, he's appearing here and trying to sue on behalf of his mother as the executor. Per statute, he is stepping into the shoes of his mother, is trying to claim damages and distributions related to the account and benefit from the agreement, but then say, oh, because he didn't sign it, he shouldn't be subject to it. And I submit to you that argument taken to its logical conclusion would make the entire job of an executor essentially meaningless and impossible. If they had to have signed every agreement that the decedent also signed in order to sue on behalf of the decedent, I'm pretty sure their job would be rendered meaningless. And taken to its logical conclusion, I think that's contrary to law and would make their job essentially ineffectual. Judge, and Eric, I don't know if you wanted to add anything in response.
No, Jasmine, I think you've covered all the relevant points. I just would reiterate one of them that you made, which is it would be surprising to me that if this agreement wasn't meant to be binding, then if you accept that position, Your Honor, then it shouldn't be binding on Waddell and Reed or Linda Howard either. So you'd be putting the executor in a worse position if you were to accept that argument.
And the argument you're making that Mr. Cogburn is a beneficiary of the agreement is based upon the simple fact that part of Mom's estate sitting at Waddell Reed. Is that correct? Not that he was a named beneficiary in anything, or was he?
No, you're correct, Your Honor. The will that Mr. Wright raised, I'm not aware of that other than him referring that to me and telling me that he was a quote unquote beneficiary. But Mr. Cogburn was not a named beneficiary on the account at Waddell and Reed. We're arguing that he is a beneficiary of the fact that the agreement exists, which gives him standing as executor to sue Waddell and Reed and Ms. Howard.
Okay, I just wanted to be clear on that because I think I understood that. Let me ask you this, where are y'all at on discovery? Have y'all done discovery or performed any?
We haven't yet, Your Honor.
Okay. And if I guess either way, if I enforce the agreement and say we're going to arbitrate, or I don't enforce it, and y'all come back to me in 6 months, you're still going to, I'm going to suggest you'll have to mediate or something. And I'm just curious where you're at on the discovery piece of this. And so
I think we can conduct the discovery in pretty quick fashion, and a mediation would be fine.
Let me ask you this, with discovery,
Your Honor,
may
if
I
I
also?
could, if I
sorry,
could.
one at a time, Mr. Wright.
Okay. It seems to me that Waddell and Reed, who wrote this agreement, wants to rewrite it. They could have written this agreement so that when Courtney Davis signed it, it bound not only her mother, but her heirs, executors, assigns, and the whole universe. But Waddell and Reed did not include that language in the agreement, and now they want to rewrite it and have this court look at it so that it does include the executor, the estate, and the assigns. Well, that's not what happened. We've got to look at the contract the way it's written. Waddell and Reed wrote it, and I think the court should enforce the contract as it's written. And as it's written, it does not include the executor, and therefore their motion to compel arbitration should be denied.
Mr. Shorttrain.
Yeah, Your Honor, and I would just respectfully say, I am genuinely surprised by the argument that counsel is making here, considering the fact that if I came to you and said, because that language wasn't there, Ms. Cogburn's executor has no standing to sue us, and therefore the case should be dismissed, I would find it hard to believe that Your Honor would disregard the existence of that contract and that we would allow to be opportunistic in that scenario and suggest that there are zero duties that flow from Waddell and Reed or Ms. Howard to the executor of the estate. I think you would roundly reject that position. I wouldn't even be willing to make it in your courtroom. I'll address that point first. Second, regarding discovery, as you can see, the amount in controversy isn't tremendous here. When you're in FINRA arbitration, I'm not sure whether you're aware of FINRA's discovery rules, but there is a standard protocol whereby discovery is standardized among the parties, and we don't engage in protracted discovery requests or responses. Oftentimes there's standard lists. There are two of them that the parties are required to abide by. And so discovery as a matter of course happens rather quickly, and it is in fact cost effective, more so than Texas law would allow for. There are no depositions, there is straightforward document discovery, there are other written requests. But in the interest of expediting this, it's far more efficient for us to conduct discovery in a FINRA arbitration format than it is if a matter is pending before a Texas state court. And that's certainly no offense to your domain, Your Honor. It's just that the industry disputes that involve customers and financial services companies and representatives have just become so standardized that this has become an effective means to conduct prompt discovery. That's all I'm trying to get at there.
And you are right. I do not know anything about FINRA discovery, so it's a new thing for me. But I'm curious if you could just give me a thumbnail version of what FINRA discovery entails.
Sure. There are specifically two lists that are included, and those have a laundry list of information that's required to be produced, especially by the financial services company and the representative. So it would include anything and everything that related to the relationship, such as communications, notes, documents, any recorded telephone calls, any financial related information, so profit and loss to the accounts, the types of transactions that occurred in the accounts. So for example, when I just want to highlight one thing about that, the financial transactions. I know Mr. Wright is under the impression that there were options tradings in the account, but there weren't. There were stop loss orders that were put into the account. And so he would get a quick explanation regarding the types of transactions that appeared on the statements. And I think he would, upon seeing that, see that there is no deceptive trade practices claim to be brought forth, because that's the basis for which that claim is made. There would be any number of internal reports that were prepared by the financial services firm that weren't privileged. And that's just to name a few. But certainly it would include all of the relevant communications and documents that would give rise to this account. Indeed, I'd also mentioned the policies and procedures that the financial services firm follows when accounts are established and accounts are distributed. So in the case of TOD accounts, Mr. Wright would be entitled to request all policies and procedures that the firm and its financial representatives follow when they need to establish certain types of accounts. So he would be well positioned to get an understanding of what happened when the account was established and all the way through its distribution based on the company's policies. Let me stop there.
Question, would that discovery go both ways as far as Waddell Reed would be supplying all that information you just gave, but would it go the other way around where they would ask the same questions to Mr. Wright's client so he could supply it also, as well as Ms. Davis? And
Yeah, yes.
Ms. Davis, all parties?
Yes, to the extent that they had those types of communications. The financial services firms are under very restrictive document preservation requirements pursuant to the SEC's rules. So we maintain communications for up to 7 years after the account closes. So I don't know how far back, Mr. Cogburn has access to his mother's documents, or for that matter, Mr. Davis excuse me, I'm sorry, Courtney Davis or Mr. Davis, her son. Forgive me, I'm going on a little sleep here, but I think insofar as that's concerned, yes, there would be reciprocal discovery, and it is fulsome. And in the event that there is a discovery dispute at all, this is heard by the arbitration panel in its regular course. And the arbitration panel also has the ability to sign off on third-party subpoenas to the extent that Mr. Wright is interested in obtaining information from other sources, such as the Hondo Bank or others. So he has a full and fair opportunity to try his case in a FINRA arbitration forum.
And then arbitration can be held you're in Dallas, and Mr. Wright, you're in Houston. I'm not making a decision. I'm just asking questions. So when I hang up here, I'm gonna read your cases, and then I'll get back with you this afternoon. But I want to make sure I have everything buttoned up before I hang up here.
Yes, Houston is a venue.
Okay, Judge, I'd like to add something if I may.
Go ahead.
One issue that the defense has not raised is what the cost of the arbitration is going to be. And the cost of the arbitration has to be paid upfront, which will be another huge expense to the estate. Secondly, according to counsel's description of the discovery limitations in the FINRA proceeding, then we would not be able to get full discovery on our claims of the conspiracy that Courtney Davis entered into with Linda Howard to liquidate the estate and deprive the other beneficiaries of the estate of their fair share of the estate assets. That would be another reason not to go to arbitration.
Well, may I respond to that?
You may.
Ms. Howard is required to participate in this case. She's a licensed representative. And if Mr. Wright had a hearing on this matter, he would certainly have an opportunity to cross-examine Ms. Howard and take her testimony along with that of any corporate representative of Waddell and Reed. So for purposes of prosecuting his claims, he will have every opportunity to do so in a FINRA arbitration forum, and he will be able to submit individual requests to Ms. Howard in addition to other requests that he may have that are germane to his claims. And so I think, again, I don't want to conflate the issues of fairness of discovery, even though there is ample opportunity during the discovery process with FINRA to allow Mr. Wright and Mr. Cogburn to prosecute the claims that they believe are relevant here. But more importantly, the agreement itself is typically what governs the court's decision regarding whether it's enforceable. And so just want to bring back that point. And yes, Houston is a venue where arbitration can occur. With regard to the cost of arbitration, yes, there are parties that are costs that are assessed to parties, no different than other court costs that might be incurred for parties. And that's something that is just a practical matter. It's not significant, but it is there. And I won't dispute that there are costs to arbitrating, but they are in the few $1,000 range, not tens of thousands of dollars range, just so you're understanding.
So can you give me what you would expect arbitration to cost in this case? A ballpark.
For whom, Your Honor? For
this case, what would it cost per party to arbitrate this case?
For filing fees or?
No, to actually go through the arbitration process. I'm just curious what the cost is to do that. I know what it costs to do a mediation. I do not know what an arbitration under FINRA would cost. I'm just curious.
Yeah, I could ballpark it, Your Honor, but we definitely haven't started the actual process yet, simply because we've been here for a few months. I would say from a defense side, the parties would probably spend through hearing $30,000. Given that a lot of the work is done at this point on the account documents, we have everything pulled. And we've given this case a very holistic assessment. I could probably defend this case, or Ms. Sharma, for $30,000 or less.
That's to arbitration?
Through arbitration.
Any other comments or statements anybody would like to make?
Nothing,
Yes.
nothing further, Your Honor.
Mr.
Yeah,
Go ahead.
The one thing I just wanted to say, Your Honor, was that as part of FINRA's process as well, mediation is incurred. FINRA has a process whereby after a statement of claim, also known as a petition, is filed, they will try to assign a mediator if the parties are willing and interested in mediating. I've expressed to Mr. Wright, that we would be amenable to mediating this matter. And we would be glad to do so.
So, and Mr. Wright, I think I heard you say you would be amenable to mediation.
Yes, I am.
Then why don't y'all move forward and do that? I can order it, but I'm just curious, if you're both agreeable to doing mediation, why don't you move forward and get that done?
We can work on that.
Okay, Mr. Chartain, I think you cut out. You're not moving. So does it look like he's locked up?
He's stuck.
Ms. Sharma? Ms. Sharma, can you hear me?
I can hear you, Judge.
I think Mr. Chartain, I'm sorry.
No, you're fine, Judge.
I think he is, here he comes back again.
I apologize. I've got a great home office setup, but sitting outside so my wife can sleep is not conducive to having hearings.
I understand.
I'm sorry.
I'm just curious. I asked the question, if you're both agreeable to mediation, why don't you just move forward and do that? It may be less expensive.
Understood. I've put the request out there, Your Honor. I can't say why Mr. Wright. I know he was inconvenienced by the flooding and the freeze. He's been very occupied with getting his office back in order, as far as I can understand. So I won't say he's not interested, because I think he is. I just don't think timing has allowed that to happen yet.
Okay.
But I do think, as a practical matter, we would be glad to do so through FINRA's forum, and that can be expedited as soon as the matter is filed there.
Mr. Wright, are you okay with that?
I oppose that. I'd rather get a regular mediator, and the cost is so much cheaper. And we're not talking about zillions of dollars here. So, $40,000 in expenses for an arbitration eats into the state's assets in a big way. So I would propose that we just choose a mediator that mediates cases all the time, and just what I would call a regular mediation.
Okay, and Mr. Shartan, you're opposed to that? I'm sitting here acting like a mediator. I'm not. I'm just, you're locked out on me again, Mr. Shartan. I'm sorry. And you're back, I think. No, I think he came back.
I'm back. Sorry.
Okay, that's all right. Technology's not my favorite either, okay? So
Thank you.
I don't know which part of my question you may or may not have gotten to, but I was just going back to just one last question, and that is, are you opposed to going through the standard mediation route?
My client would prefer this to go through the FINRA arbitration route, Your Honor. I can't say that I'm opposed because I've not visited that question with our client, actually our clients, because we represent both
Sure.
Ms. Howard and Waddell and Reed. So I can't answer you to suggest that we're not. I will say this. I think Mr. Wright characterized arbitration as a regular arbitrator. Just so Your Honor is aware, the arbitrators, or excuse me, mediators. The mediators are all licensed attorneys and licensed mediators.
Sure. It's cut out again. So, Ms. Sharma, just so we can get this wrapped up, I am going to read your cases, Mr. Wright. I would encourage, I'd like for Mr. Wright, Mr. Sharpton, are you back? I think you're moving.
Yes, sir.
Okay, good. I'm going to read your cases and I will make a decision. I would like for y'all to, when I hang up, to sometime this afternoon get together just to see if there is a possibility of coming to an agreement on mediating. Otherwise, I'll make a decision, okay?
Okay. Thank you.
Thank you, Your Honor.
All right.
Thank you.
Anything else?
No, thank you.
No, sir.
All right. Thank y'all.
Thank you.
Thank you, Judge. Thank you,
Bye.
everyone.
Thank you. Goodbye.